what to do, whereafter the state would respond. Mr. Orengo, for all accused, argued that accused 1 traveled for over 300 miles to meet the EACC officers after he was confronted with the charges facing him. In doing so, accused 1 presented himself freely in respect of the law and the role of the EACC. The other accused had presented themselves to the EACC Kisumu and were brought to Nairobi on the morning of 4th July 2018. He submitted that since all the accused had demonstrated respect for the law and appeared voluntarily, they should not be made to suffer. According to him, the charges facing the accused contained falsities in that, contrary to what was contained in the charge sheet on arrest of accused on 3rd July 2018, no such arrests had been made. All documents needed by the EACC from Busia County during investigations had been supplied. The case had existed since 15th March 2014. Stressing that bail was a constitutional right, he argued that there must be reasons for denial and the presumption of innocence found in Article 52 of the Constitution must be protected. The burden of proof why bail should be denied lay on the prosecution. He urged the court to rely on the bail and bond guidelines as published by the NCAJ. The court was urged to look at several paragraphs in those guidelines. While attacking specific averments in the affidavit filed by the prosecution, Mr. Orengo submitted that there was nothing that had been placed before the court to demonstrate that the 4 accused who presented themselves to court were flight risks, and the issue of not attending court could only be related to the other accused who did not appear. That Section 62(1) of ASECA required accused 2, 5, and 6 to vacate office, and there was no likelihood of the interference with witnesses as alleged in paragraph 13 of the prosecution's affidavit. He urged the court to refer to the case of Rogers Nzioka and others versus Republic. That was application number 12 of 2018, where more serious charges and more money was involved. That amount should not be used as yardsticks for denial of bail. He argued that grant of bail would ease resources of the country and allow accused persons time to prepare for their defenses, suggesting a cash bail of 100,000, which he was ready to pay and go away with Ojaamong. The response by Mr. Alex Muteti for the state was of the argument that Article 49 of the Constitution provided for denial of bail where there were compelling reasons. Each case was to be judged with its own facts, that the case before the court was peculiar. To that, unlike that in the miscellaneous application number 12 of 2018 before the High Court, while referring to paragraph 8 of the affidavit, Mr. Muteti argued that the conduct of the accused is antecedents and associates should be borne in mind when considering whether to grant or deny bail. The accused had mobilization capacity. He could therefore mobilize citizens as he had done and interfere with witnesses who were said to be employees of Busia County, where the accused was the boss. The witnesses would be so intimidated that their guarantee to appear in court was not assured. Further, that as a state officer, Section 62 of ASECA was not applicable, as he could not be suspended or interdicted and would therefore remain in office as an accused person and would scare junior employees in walking to the court. That when an accused continues to hold office, one has to strike a balance between justice and the risk it poses to the just determination of this matter. That all that was needed to convince the court was a demonstration of actual or perceived interference and should not go for actual threats, and that such threats have to be muted. On witnesses, Mr. Muteti informed the court that Wahome, the deponent of the affidavit, was the investigating officer and therefore one of the witnesses. that there were witnesses in this country who disappeared and were found dead, therefore a compelling reason to consider the safety of the witnesses. That during case management it would come out clearly why the names of the witnesses do not appear on the charge sheet. This is because it would be defeatist to supply the names of the witnesses where witnesses are threatened, and he referred the court to Section 4 of the Witness Protection Act. That Mr. Ojaamong cooperated later when he realized what was facing him, and that under Article 24 of the Constitution, right to bail was not one of the inderogable rights, and that the right to bail was limited. He urged the court to find that the affidavit brought out compellable reasons to deny bail. While supporting Mr. Muteti's submission, Mrs. Murungi urged the court to look at the case of Frederick Oleleiman and others versus the Republic, case number 57 of 2016, paragraph 73 thereof. That paragraph demonstrated, and the court held, that attack on deceased was intended to interfere with the trial before court, which interference was serious and would interfere and obstruct the course of justice. That the affidavit by Mr. Ome demonstrated that the accused were likely to interfere with witnesses in this case. Sorry. She also urged the court to look at the case of Jackton Mayende and 3 others, that is High Court Criminal Case number 55, 2000 at Bungoma. The accused were influential persons within Busia and were likely to terrify witnesses and hence make them fail to give evidence. In their rejoinder through Mr. Ligunya, the defense buttressed their case that the deponent of the prosecution's affidavit did not tell the court that from the year 2014 to date, any of the accused had done anything to influence witnesses. While referring to the authority supplied by the prosecution, that is the authority of Oleleiman, Mr. Ligunya submitted that all accused were clean and had not interfered with the witnesses. That what the court required was material evidence and not allegations. That as alleged in the affidavit, the court was not told where in Busia demonstrations were, whether accused sanctions the demonstrations or whether they were spontaneous. On Mr. Ojaamong's press statement, the affidavit did not indicate when the press conference took place, where it was held, and when it was reported. That not even a newspaper extract was brought to court. Though in paragraph 19 of the affidavit it was indicated that the prosecution was ready to proceed, readiness for trial could not be a reason to deny bail. No facts had been laid before the court to demonstrate that accused one would interfere with witnesses. Mr. Omari argued that if bail is denied to accused one, accused one would remain in remand for 4 years, which would occasion a by-election in Busia County, causing massive prejudice to the people of Busia. While supporting Mr. Omari's position, Mr. Airo informed the court that the people of Busia needed protection. Needless to repeat that the prosecution relied on the affidavit sworn by Mr. Wahome. I took time and perused the same very carefully. The court was also urged to look at the bail and bond policy guidelines, the Constitution, Ms. Linda's application 12 of 2018, High Court Criminal Case number 55 of 209 in Busia, and the case of Frederick and others versus the Republic. That one I did. Bail is anchored under Article 49, G and H. This provision of the Constitution states as follows. 49, an arrested person has the right, that is in G, at the first court appearance to be charged or informed for the reason for detention continuing or to be released. At H, to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons to be released, not to be released. On the burden of proof, Section 107 of the Evidence Act, Cap 80, provides as follows. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. 107.2 states further that when a person is bound to prove the existence of any fact, it's said that the burden of proof lies upon that person. Paragraph 3.1e of the bail and bail bond policy guidelines says, bail determination must balance the rights of the accused and interests of justice. Here it's required that the liberty of the accused is preserved and based on the presumption of innocence, which will permit him, accused is preserved based on the presumption of innocence, which will permit him or her to take an active role in preparing defense. However, if there is convincing evidence that the accused may undermine the integrity of the criminal justice system, i.e. by intimidating witnesses or interfering with evidence, then the need arises to deny that person bond or set stringent bond terms. Well, I did not find Section 3.9, which was referred to. Section 4.2, which was referred to, deals with situational analysis when dealing with bail and bond in the police station. So it's also not applicable here. Section 4.9 provides that in terms of substance, the primary factor to be considered by the courts in decision making is whether the accused person will appear for trial if granted bail. The decision whether there are compelling reasons that can justify the denial of bail should be made by evaluating whether or not the accused will attend trial. In miscellaneous application number 12 of 2018, which I've mentioned, Ongudi J. held that readiness by the prosecution can only make sense where one has been denied bail. On interference, that she found that the court would require material evidence placed before it in respect to such interference for determination to be made on it. The issue of interference was deponed to in paragraph 6 and 7 of the prosecution's affidavit. However, one point of interest on this issue that elicited the court's unbaffled attention is to the assertion by Mr. Mteti that the court will be told at the pre-trial conference why names were not included in the charge sheet, and hinted that it would be dangerous to do so. On the other hand, Mrs. Murungi, while relying on the case of Jackton Mayende and 3 others which I have mentioned, and the affidavit submitted that the witnesses are likely to be terrified, the question then to ask is, who are these witnesses? Are the accused privy to their identity? That was not demonstrated to the court. Under the Witness Protection Act, the identities of the witnesses can be hidden from the public for the safety of the witnesses. I have looked at paragraph 8, 9, and 16 of the prosecution's affidavit. Paragraph 9 does not indicate the source of information as required when a deponent of an affidavit is relying on any information to support his cause. The source of information must be indicated clearly. On the issue of accused before court today being flight risks, the said affidavit does not mention any of them as being flight risks, but mentions accused 3, accused 7, accused 8, accused 9, and accused 10 in paragraph 10 and 14 of the affidavit. The said accused are not before court. On the issue of accused 1 being an influential state officer who has demonstrated his capacity to mobilize his supporters to interfere with the course of justice, I have informed myself on the particulars contained in paragraph 8 and 9 of the prosecution's affidavit. The accused is charged herein in Nairobi. There were no facts how he would mobilize his supporters to interfere with the course of justice here in Nairobi. After listening to the submissions by both parties, there is no dispute as to the serious nature of the charges facing the accused. The prime purpose of affording the accused bond is to ensure that the accused attend court for trial. Consequently, I make the following orders. Number 1, accused 3, accused 7, accused 8, and accused 10 to be traced, arrested, and arraigned in court for the various offences facing them. Respective warrants of arrest against each and every one of them is hereby issued to be executed by the investigating officer in this case. Number 2, all the 4 accused persons present to be released and or are admitted to bail in the following terms: each to sign a bond of Kenya shillings 3 million, each to be released on a bond of Kenya shillings 2 million plus one surety of similar amount, or alternatively, each to pay a cash bail of Kenya shillings 1 million. Each to report to the investigating officer in this case at the EACC Malaba office pending the determination of this case on the last Friday of each calendar month, unless that day falls on a day that accused are required in court. Those are my orders today. Yes.
Busia Governor Ojaamong has finally secured himself a bail. The judge has ruled that he is giving them a 1 million shilling cash bail for the governor as well as his co-accused. Remember, the governor spent 2 nights at the EACC cells at Integrity Center. They are being represented by lawyer James Orengo, who said that his client will fully cooperate with the officials investigating this particular 8 million shilling case with regards waste management project. And of course, Timothy Otieno is there. He will be giving us more details about that ruling that has just been given. Once again, Sospita Ojaamong, governor for Busia County, has managed to secure himself a bail of 1 million shillings from that particular ruling, together with his co-accused, and he's been ordered to report to the DCI headquarters every Friday as investigations continue. Once again, Timothy Otieno will continue to give you updates in our subsequent bulletins. It's now time for sports. Our reporter